The letter arrived on my birthday. I know because I had just turned 34, and my phone had been quiet all morning in the specific way a phone is quiet when the people who are supposed to call have decided not to. I was getting ready for a 12-hour shift at the pediatric unit when I heard the knock at the door, the specific knock of someone who needs a signature. A certified letter. Return address, Blevins Estate Law, Nashville, Tennessee. My mother's attorney. I signed for it. I set it on the kitchen counter. I made coffee and looked at it for 2 minutes before I opened it. 4 pages. The first page was a cover letter on firm letterhead. It explained, in the professional language of legal correspondence, that as per the final wishes of Richard and Eleanor Whitfield, the estate, including the Nashville property, the lake house on Norris, the investment portfolio, and all personal property, had been distributed in full to Amber Christine Whitfield. It explained that Claire Marie Whitfield had been excluded from the estate at the specific direction of both parents. Then it said, "Please see enclosed invoice." The invoice was 3 pages. It was itemized. $47,218. The cost of raising me, calculated from birth to age 18, a portion of the mortgage across years of residence, groceries divided by household members multiplied by years, school supplies by grade, medical copays organized by date, the fee for the music lessons I had asked to quit after 8 months and which my mother had made me finish. Every line had a date. Every date had a dollar amount. At the bottom, a total, and below the total, a due date, 60 days from receipt. I stood in my kitchen in my scrubs on my birthday and read all 3 pages. Then I called the number on the letterhead. Welcome to Quiet Karma Stories. My name is Claire Whitfield. I am a pediatric nurse in Nashville, Tennessee. I was born the second child of Richard and Eleanor Whitfield. My father was a civil engineer. My mother managed the household and the money with the specific precision of someone who has decided that control is the same thing as love. My sister Amber is 4 years older than me. She lived with my parents for most of her adult life, in the east bedroom of the Nashville house, working part-time at a framing shop and helping my mother manage my father's care after his diagnosis. My father has early-stage dementia. Has, present tense. He is still alive. He did not attend the reading of his own will. He did not know a bill had been sent. The list Gerald Hatch had was different from the one my mother prepared. My father had made sure of that, 12 years before anyone thought to ask. My father built things carefully and quietly. He was a civil engineer for 31 years, which meant he understood that what holds a structure together is never the visible part, it is the foundation work done before the first wall goes up, in the planning phase, when most people are still deciding what they want to build. He applied this to his career, to the house he designed and had built in East Nashville in 1987, and to his finances. By the time I was in high school, the house was paid off. By the time I graduated from nursing school, my father had 3 investment accounts, a lake property on Norris that he had bought from a colleague for $40,000 in 1998 when the land was still undervalued, and a watch collection that had started with his own father's pieces and grown over decades into something a jeweler in Nashville had appraised at $240,000. The total estate value, at the time of the certified letter, was approximately $2.4 million. Amber knew this number. She had been living in that house, helping my mother organize my father's paperwork and doctor's appointments, for 9 years. She knew the account numbers. She knew the name of the investment advisor. She knew the attorney's name was Sharon Blevins because she had attended the meetings. I did not attend the meetings because I was not invited to the meetings. What I knew, my father was kind and precise and had always been present in the specific way that quiet fathers are present, not loudly, not with speeches or gestures, but with small consistent acts of attention. He remembered what I liked. He came to every graduation. He called every Sunday until the Sunday he no longer remembered to call. What I did not know, until I was 34 years old and holding a 4-page letter on my birthday, was that he had gone to see a different attorney 12 years earlier. Not Sharon Blevins. Not anyone my mother had recommended. Gerald Hatch. A trust and estates attorney with an office on 5th Avenue North. My father had made an appointment, driven himself there, sat across a desk, and described exactly what he wanted to happen to specific assets in the event of his death, before his death, in a document that would not require probate and could not be contested the same way a will can be contested. He had done this alone. He had told no one. He had done it because, as Gerald Hatch told me later, he had said across the desk, "My wife is a precise woman. I want to make sure some things are taken care of before she gets precise about them." The woman who answered the phone at Blevins Estate Law was professional and slightly guarded in the way of office staff who have been briefed that a call like mine might come. "I need to speak with Sharon Blevins about a letter I received this morning." "May I ask your name?" "Claire Whitfield. The letter concerns my parents' estate." A pause. One moment. Sharon Blevins had the voice of someone who had been doing estate law for 20 years and had learned to present difficult information with the specific neutrality of a weather report. She confirmed that the letter was real. She confirmed that the will had been executed 8 months earlier, that both Richard and Eleanor Whitfield had been present, that Richard had been assessed by a physician as having sufficient capacity to execute legal documents at the time. He had capacity at the time of signing? He was assessed and found to have sufficient capacity, yes. By a physician my mother arranged. A brief pause. The assessment was conducted according to standard protocol. I looked at the invoice on my kitchen counter. The invoice. The $47,000 invoice. That document was prepared at your mother's direction and reflects costs she has documented over a period of years. It is a bill for the cost of raising me. It reflects documented household expenditures attributed to your residence and care during your minority. Sharon. A pause. Is there anything about this situation you believe I should know? A longer pause this time. When she spoke again, her voice was the same, neutral, professional, but there was something careful around the edges of it, the specific care of someone choosing words with the knowledge that they might be repeated in another context. Ms. Whitfield, I prepared the documents I was retained to prepare. I would encourage you to consult with your own legal counsel regarding any aspects of the estate you believe warrant review. She said goodbye. She ended the call. I sat down at the kitchen table. 3 days later, Gerald Hatch called. The call came on a Tuesday morning. I was on the couch with coffee and my laptop, looking at the Tennessee probate code in the specific way of someone who has spent 3 evenings reading legal documents they do not fully understand and has decided to start from the beginning. The number was a Nashville area code. An office prefix. Claire Whitfield? Yes. My name is Gerald Hatch. I'm a trust and estates attorney with Hatch & Coburn, on 5th Avenue North. I was the drafting attorney and trustee for a revocable trust created by your father, Richard Whitfield, approximately 12 years ago. I've been monitoring the public filings related to your parents' estate, and I saw the probate opening last week. I believe it's the appropriate time to contact you. I set down my coffee. A trust. A revocable living trust, yes. Your father created it in, a brief pause, papers, February, 12 years ago. He funded it at creation with specific assets. I am the named trustee. You are the named beneficiary. He never told me. He asked me not to. He was specific about that. He said, and I'm reading from my notes from our initial meeting, if she knows, Eleanor will find out. I want this to be settled before it becomes a conversation. I was quiet for a moment. What assets did he fund it with? The lake house on Norris. 3 investment accounts that he transferred into the trust at the time of creation. And the watch collection, which is inventoried in an exhibit attached to the trust document. I looked at the probate notice I had pulled up on my laptop. The estate my mother's attorney had probated, the Nashville house, some personal accounts, the contents of the family home, was real. She had left those assets to Amber. She had probated exactly what was left after my father had quietly moved the rest. Gerald. A pause. What is the current value of the trust assets? The lake house was appraised last year at $890,000. The 3 investment accounts have a combined current value of approximately $1.1 million. The watch collection, at the most recent appraisal, is $240,000. $2.23 million. Sitting in a trust my father had built 12 years ago, on a Tuesday morning in February, in an attorney's office on 5th Avenue North, before he forgot my name. When can we meet? I said. I'm available Thursday morning. I'll be there. Gerald Hatch's office was on the 3rd floor of a building that smelled like old wood and document paper, the specific smell of a place where careful things are kept for long periods. He was a man in his late 60s with reading glasses on a chain and the unhurried manner of someone who has been holding information for 12 years and has been waiting, with professional patience, for the correct moment to deliver it. He opened a folder on the desk between us. Your father came to see me in February, 12 years ago. He found my name through a referral from a colleague, not through any contact connected to your mother or to anyone in your family's existing network of advisors. He was deliberate about that. He came alone. He came alone, yes. He drove himself. He was completely clear during our entire consultation. His instructions were precise and he had thought about them in advance. He brought a handwritten list of the assets he wanted to move into the trust. He placed a photocopy of the handwritten list on the desk. My father's handwriting. The careful, architectural print of an engineer, each letter formed completely, no letters running together, the spacing even. The lake house. Account numbers for 3 investment accounts. A note that said, watch collection, see attached inventory. My father had brought a typed inventory of the watches, each piece described with its approximate value at the time, the original owner noted were applicable. He said to me, during our meeting, my wife is a good woman in many ways. But she has a favorite. I have always known who the favorite is. I am not going to be able to stop what happens when I'm gone, but I can make sure Claire has something that cannot be touched by what happens. I looked at the handwritten list for a moment. He knew. He was very clear that he knew. He also said, and again, I'm reading from my notes, I won't tell Claire because she'll worry. And I won't tell Eleanor because she'll act. He wanted the trust to exist and to do its work without becoming a source of conflict during his lifetime. He funded it immediately? He began the transfer process that week. The accounts were retitled within 30 days. The lake house deed was transferred to the trust within 60 days. He brought the watch collection inventory to a second meeting and we attached it as Exhibit A. The watches. My grandfather's watches. I had grown up watching my father wind them on Sunday mornings. He had shown me how each one worked. He had told me, more than once, that they would be mine someday. He had meant it specifically enough to put it in a legal document. The trust is irrevocable upon his death, Gerald said. It was revocable during his lifetime, he could have dissolved it. He did not dissolve it. As of the date of his incapacitation, the trust became effectively permanent. The assets in the trust did not pass through his estate. They were never subject to his will. They cannot be included in the probate your mother opened. I looked at the handwritten list one more time. He planned this for 12 years. He planned it carefully, Gerald said. In my experience, that is exactly what a father who loves his daughter and knows his household does. What I know about what Amber knew I learned across several weeks, through Gerald's research into the estate timeline and through one phone call I made and immediately regretted making. I called Amber on a Thursday evening, 10 days after meeting with Gerald. Claire. Her voice was careful. Prepared. She had been waiting for the call. I want to ask you something directly. Okay. Did you know about the trust? A pause. No. Did Mom know about the trust? A longer pause. Not until last week. How did she find out? The probate search. Her attorney ran a title search on all the properties and found the lake house deed was already in a trust. She called me. She was she was very upset. I imagine. Claire, she worked very hard to make sure everything was handled correctly. She spent years preparing a 4-page invoice for the cost of raising me and sending it to me on my birthday, Amber. Silence. I didn't know about the invoice until after it was sent. I want you to know that. Did you ask her not to send it? A pause. I told her it wasn't necessary. But you didn't stop it. I didn't, a breath. I didn't think she would actually send it. Amber had known about the will changes for 8 months. She had been present at the meetings with Sharon Blevins. She had been in the house during the financial reorganization. She had known that I was excluded. She had not called me. She had not warned me. She had not known about the trust. This was the one piece of information that was genuinely new to her, the one thing that had existed outside the boundaries of what Eleanor had controlled and therefore outside the boundaries of what Amber had known. The lake house, she said, after a long pause. Dad used to take you there. Just you. Every summer. She stopped. I know, I said. I didn't think, I never thought he would. He did, I said. He did it 12 years ago. Good night, Amber. I hung up. I noted the call in the file I had started the morning after Gerald's office visit. Date, time, 15 minutes. Then I went back to reading the trust documents. I returned to Gerald's office on a Friday morning with a yellow legal pad and the 4-page invoice, which I had placed in a clear document sleeve and kept in a folder since the day it arrived. Gerald had the full trust document printed and tabbed. We went through it section by section. The lake house. Deed transferred to the Whitfield family trust 12 years ago. Claire Marie Whitfield named as sole beneficiary upon the grantor's death or incapacitation. Current appraised value, $890,000. The 3 investment accounts. Account numbers matching the handwritten list. Combined current value, $1.1 million. Transferred into the trust at creation, retitled in the trust's name, continuously managed by the same advisor my father had used for 20 years. The advisor, Gerald told me, had been aware of the trust. Had been specifically instructed by my father to make no mention of it to Eleanor and to continue managing the accounts as normal. The watch collection. Exhibit A, 63 pages. Every watch described. The first item on the list was my grandfather's 1947 Langhans. The last item was a chronograph my father had bought himself in 1995, his first year as senior engineer. Between them, 40 years of careful acquisition. The total documented value of the trust assets, Gerald said, is approximately $2.23 million. I looked at the invoice in its clear sleeve on the edge of the desk. The estate my mother probated. The Nashville property and the remaining accounts, approximately $170,000 in total. She probated everything she knew about. Which was everything outside the trust. Correct. Your father structured it so that the most significant assets, the lake house, the primary investment accounts, the collection, were moved into the trust before Eleanor had reason to anticipate it. She has spent 9 years managing his care and his finances, and in all that time, she did not find the trust because it was not in any file she had access to. The deed to the lake house, when she checked the county records, shows the Whitfield family trust as owner. She assumed it was a standard joint trust she had been a party to. It was not. She discovered it when you opened the estate process. Her attorney discovered it during due diligence on the probate. At that point, they had a problem. What kind of problem? Gerald took off his reading glasses. The kind of problem that happens when you send a $47,000 invoice to someone who turns out to be the beneficiary of $2.2 million in trust assets. The kind of problem where the invoice, combined with the will's explicit exclusion of the trust beneficiary, creates an evidentiary record of intent that is very useful in a legal proceeding. He placed the invoice sleeve in the center of the desk. "Your father left you a trust," he said. "Your mother, without knowing it, left you evidence." Eleanor called me on a Saturday morning, 9 days after my meeting with Gerald and 2 days after Gerald had formally notified Sharon Blevins of the trust's existence and Claire's beneficiary status. The call lasted 11 minutes. "I want you to understand," she began, "that your father was not in full possession of his faculties when he created that document. Gerald Hatch has records from 12 years ago showing full legal capacity. He has notes from their consultation. He has my father's own handwritten list of the assets, in the handwriting of a man who was completely unimpaired. Your father was always easily influenced." "By whom?" "He went to that attorney alone. He found him independently. He transferred the assets over 30 days without telling anyone. He should have discussed this with the family. He discussed it with his attorney. He funded a trust. He updated it every 3 years, which I understand from Gerald means he reviewed it and confirmed his wishes. 3 times, in 12 years, he drove to that office and confirmed that he wanted me to have those assets." A pause. "The lake house was a family property. The lake house has my name on the trust deed. Your father had sentimental ideas. He had a legal document." A longer silence. "Claire." Her voice changed, not softer exactly, but carefully adjusted. The specific adjustment of a woman who has decided to try a different approach. "I know things between us have not always been easy. I know you feel that Amber and I have a certain closeness that didn't exist between us. I want you to know that was never intended to." "Mom." She stopped. "You sent me a bill. On my birthday. For raising me." She was quiet. "Whatever you intended, that is what happened. I have the document in a clear sleeve on my desk. I have Gerald's documents in a folder next to it. On Tuesday morning, both sets of documents are going to be in the same room." "What happens Tuesday?" "Tuesday is when we sit down and figure out what the next 12 months look like. Gerald will be there. Sharon Blevins will be there. You and Amber are welcome to bring whoever you need." She said nothing for a moment. "I want you to know," she said, "that your father loved you." "I know he did," I said. "He proved it 12 years ago." I ended the call. The meeting was in a conference room at Gerald's office on Tuesday morning. Eleanor and Amber arrived with Sharon Blevins and a second attorney, a litigator Sharon had brought in when it became clear that the trust's existence was not going to be resolved by a phone call. Gerald and I arrived separately. I had the invoice in its clear sleeve in a folder on the table in front of me. Gerald had the full trust document, tabbed, with the handwritten list in Exhibit A and the 3 capacity confirmation memos from my father's triennial reviews. The litigator, whose name was Dennis, and who had the specific energy of a man who has agreed to take a case and has since reviewed the documents and is now managing his own reactions, opened by saying that his clients believed the trust had been created under circumstances that warranted review and that they intended to challenge it on the grounds of undue influence. Gerald placed the 3 capacity confirmation memos on the table. Each of these is a memo from my file, documenting a meeting with Richard Whitfield in which he reviewed the trust, confirmed his wishes, and explicitly stated that no person had influenced or pressured his decision. The most recent is from 3 years ago, 18 months before his diagnosis. He was assessed by his physician 4 months later and found to have early-stage decline at that time, meaning at the time of his last trust review, he was unimpaired. Dennis looked at the memos. Eleanor looked at her hands. "The trust assets," Gerald continued, "are legally titled in the name of the Whitfield Family Trust, of which I am trustee and Claire Whitfield is sole beneficiary. They did not pass through Richard Whitfield's estate. They are not subject to the probate proceedings Sharon filed. They are Claire's as of the date of Richard's incapacitation, which the physician's assessment places in the third quarter of 3 years ago. A long silence in the room. Sharon Blevins said, quietly, to Dennis, I told her. Dennis placed a legal pad face down on the table. What is your client's position on resolution? He asked Gerald. Gerald looked at me. My client, I said, is open to a resolution that does not require litigation and that does not require her to explain to her father, if he has a clear day, that his wishes are being contested in court. Another silence. Eleanor looked up. Something in her face was different from the phone call, not softer, but smaller. The specific smallness of a woman who has discovered that the architecture she believed she controlled had a foundation she never saw. What does resolution look like? Amber asked. It was the first time she had spoken. Gerald opened to the last tab in the trust document. It looks like the list, he said. Your father's list. The resolution took 6 weeks to finalize. Gerald called me on a Thursday afternoon when the paperwork was complete. The lake house deed has been transferred to your name. The 3 investment accounts have been retitled in your name. The watch collection, Gerald paused, is ready for pickup at a storage facility Sharon's office arranged. All 63 pieces, inventoried, insured, intact. The invoice. Sharon Blevins has withdrawn the invoice on behalf of your parents. It has no legal standing and, given the evidentiary context, her clients agreed that pursuing it was not in their interest. What happens to the Nashville house? It remains in the probate estate. It will pass to Amber as the will directs. The probate estate is approximately $170,000. Amber will receive the house, which has a current market value of approximately that amount. I did the arithmetic. The trust my father had built, $2.23 million. The estate my mother had probated, $170,000. The bill she had sent me, $47,218. My father had understood, 12 years before any of this happened, what the distribution would look like. He had not been able to prevent what my mother would do. He had been able to ensure that what she did not determine the outcome. I drove to the storage facility on a Saturday morning. The watches were in a temperature-controlled unit, each one in its original case, the cases arranged in order of the exhibit. Gerald had given me the inventory list. The first case held my grandfather's 1947 Langens. I opened it. The watch was exactly as I remembered it from Sunday mornings in my father's study, the cream face, the slender hands, the case scratched along one edge from decades of use. My grandfather had worn it every day. My father had worn it at my college graduation. He had taken it off his wrist afterward and held it in both hands and looked at it for a moment, and I had thought at the time that he was just admiring it. He was thinking about the list. I drove home with 63 watches in the back seat, the inventory on the passenger seat, and the invoice, still in its clear sleeve, in the folder in my bag. I have kept the invoice. Not out of bitterness. Out of documentation. It is the record of what my mother believed she could do. The trust documents are the record of what my father had already done. Both documents are real. Only one of them determined the outcome. My father built things carefully and quietly. He understood that what holds a structure together is never the visible part, it is the foundation work done before the first wall goes up, in the planning phase, when most people are still deciding what they want to build. He planned my foundation 12 years before I needed it. He was right about everything. Lessons from this story. The first lesson is about the specific power of a decision made before the emergency. Eleanor Whitfield spent years managing her husband's finances, his care, his legal documents, and his estate planning. She managed all of it with precision. What she could not manage was the document he had created before she had access to any of it. The trust existed 12 years before the will was updated. By the time the will was ready, the most significant assets were already gone, quietly, legally, irrevocably. The second lesson is about what documentation of intent reveals. The invoice Sharon Blevins prepared was a legal document. It was also an evidentiary record of how Claire's parents viewed her value to the family, as a liability to be recovered, an expense to be reimbursed, a cost to be settled. When placed next to the trust documents, the invoice did not help Eleanor's position. It illustrated it. Courts and attorneys understand the difference between a family with a dispute and a family where one member has been systematically devalued. The invoice made that difference very clear. The third lesson is this: a father who cannot stop what will happen to his daughter can still determine what she will have when it does. Richard Whitfield knew his wife. He knew his household. He knew, with the specific clarity of an engineer who has spent 30 years understanding load-bearing structures, where the weight would fall when he was gone. He could not change the weight. He built a structure underneath his daughter that the weight could not reach. He did it quietly, alone, 12 years in advance, and he said nothing to anyone until Gerald Hatch said it for him. On a Tuesday morning. In a conference room. With the list in front of everyone. The list said Claire. It had always said Claire.